Hello everyone, and welcome to our lecture recording for chapter 3. Today we're going to look at the legal systems in Australia, and we have 6 learning objectives to cover. So let's get started with the first one that asks us to explain the function of the police in enforcing the law and the role of the courts in administering the law and resolving disputes. So the starting point for this chapter is on page 46. Before we get in and talk about the role of the police and the courts, I need you to understand what we mean by jurisdiction. And you'll find that discussed in some detail on page 46. The word is highlighted in red in your textbook, so you can find more about jurisdiction in the glossary section at the end of the book. But also I remind you that you can consult the Australian Law Dictionary, which is available to you free of charge on the USQ library webpage. Now, jurisdiction simply means that each court has a limited power or authority to be able to listen to certain causes of action. Okay, so in relation to the court system, the word jurisdiction means that we have separated the areas which a particular court can look at in relation to being able to adjudicate on those matters. Now, remember that there are 9 jurisdictions in Australia. This is not talking about courts in particular, we're talking about the jurisdictions in relation to parliaments. And we have 6 states plus 2 territories, being the territories of North Australia and the Northern Territory basically, and the ACT, the Australian Capital Territory. That makes now 8, and the last jurisdiction is our federal jurisdiction, which belongs to the Commonwealth Parliament. And you will find that on page 46 they expand on the idea that the jurisdiction of each state and territory stops at the border. However, there's an exception, and they give you the example of the initiative between Western Australia, South Australia and Northern Territory, which is known as Cross-Border Justice Acts, the respective acts in these jurisdictions, which is referred to usually as the Cross-Border Justice Scheme. Okay. Now the second thing we want to talk about is the idea of litigation. Okay. And this is basically the process of bringing and maintaining a defending a legal action. And there are problems with this process because it's time consuming, and more importantly, as a rule of thumb, the higher the court in a hierarchy, the greater will be the legal costs. Alright, so let's then start on what the role of the police is in the legal system. And as you see again on page 46, the police plays no direct role in the creation of new laws, nor are they concerned with the punishment of wrongdoers, and that's a very important point. Okay? The main function of the police is to enforce the laws created by other authorities, namely the court system, i.e. common law or case law, and the statute legislation, namely the laws coming from Parliament. So they serve the law itself and are independent of the government. Okay. Now, a considerable amount of the police time is involved in work in and for the courts. So there is an interaction between the police and the courts. So some of their court work includes things like initiating and conducting the majority of prosecutions for what's known as summary offenses. Okay. So these are basically minor offenses such as shoplifting, okay, and the less serious indictable offenses such as assault. Offenses that are more serious, like indictable offenses such as robbery and murder, are brought in the intermediate and superior courts, but still start initially from the magistrate courts for something called the committal hearings. And here the police are required again to present their evidence so that the magistrate can determine whether or not the accused has a case to answer in a higher court. Now, the courts, so maybe you just say a few things about how that then affects the role of the courts. The courts, and you remember we talked about something called the doctrine of separation of powers, and we said that the courts are entrusted with administering the law and the resolution of disputes. Part of that will require imposing a legally binding decision on the parties to the dispute. So courts have two kinds of jurisdictions. Okay, so in this context we mean, by jurisdiction we mean the type of cases or matters that each court can hear. So there are basically criminal and civil jurisdictions. In the criminal jurisdiction, the court where the case will be heard is determined by the act that created the court and the seriousness of the offense. For example, if we have a shoplifting crime, and as we said earlier, shoplifting is simply a summary offense, so it is not a serious offense, it's what's known as a minor offense. Because it is a summary offense, okay, it's dealt with by what's known as an inferior court. An example of that would be a magistrate's or a local court. Okay. On the other hand, if we are looking at a more serious offense, such as murder, this is what we refer to as an indictable offense because there's an indictment against the accused. There will be a committal hearing, first at the magistrate's court, but simply to determine whether the police has enough evidence to send the accused to trial. And if that's the case, then his case, the accused case, will go to a higher court, such as the Supreme Court in a given state. Now, if a guilty verdict is arrived at, there will have to be sentencing. Sentencing in criminal jurisdiction could be either a fine, okay, or a prison sentence. Okay. And if the latter, so if there is a prison sentence, penal services, what's known as penal services, will be responsible for the convicted. The accused now is referred to as the convicted person for their punishment and rehabilitation. There's also a civil jurisdiction. Okay. In a civil case, okay, an individual or organization commences an action against another, so the state is not involved in commencing the action as it would be under criminal jurisdiction. And which one of the courts will hear the matter is set again by regulation. So this is the executive arm of government that sets an amount, and that amount of money determines which court in the hierarchy, of course, as we will discuss that very soon, which court will be hearing the cause of action. So if a party is seeking an equitable remedy, such as what we call injunction, or an order for specific performance, in most jurisdictions, the only court that can deal with the matter is the Supreme Court. And it's the only court that has an equitable jurisdiction. So it's not only the amount of money that's involved in a civil action that determines which court hears your cause of action, but also what kind of remedy you're after. So if you're after something that has to do with equitable remedies, so something like injunction, which means that you want to stop someone from doing something, for example, or specific performance, so you have a contract with someone and you want to force that person to complete their part of that agreement or contract, then you have to go to the Supreme Court. You have to go to one of the Supreme Courts. Alright, so let's then proceed to look at our second and third learning objectives. So we'll discuss them together. The second objective asks us to identify the state and territory hierarchies in the Australian legal system, while the third objective asks us to describe the objectives, hierarchy and jurisdiction of the courts in the federal court system. The starting point is to remind ourselves that since 1975 we started at least removing the links or appeal rights to the Privy Council in the motherland in the United Kingdom. So slowly until as we discussed in a previous lecture, until 1986, with the passing of the Australia Acts, that we were able to remove completely the, at least in theory, at least in practice rather, the possibility that you can appeal to the Privy Council. Now, today we have a court system where the highest court of appeal is the High Court of Australia. This is pretty much our constitutional court, and it's the final court of appeal to any court in the land, whether it's a federal court or a state court. So let's start from the left hand side of this figure, which you can find on page 48. You see that the High Court of Australia is the last court of appeal to the full court, appellate and superior divisions, and it is also the final court of appeal for the family court general division. So if there's a cause of action in the family court under family law, that would be appealed to the full court, appellate and superior division, and if the parties still would like to continue the appeal, and of course that's not really a matter of right but a matter of privilege, basically the idea that the High Court will give you leave to bring your cause of action to the High Court, and that would always be a matter of looking at the merit of your appeal, in particular whether the appeal has to do with a point in law, or the idea that there was an error in the application of the laws that applied to your cause of action. So it's not really about facts, or simply because you're not happy with the decision of the lower courts. It has to be based on a valid point of appeal in relation to the legal part of your cause of action. You could also appeal from the second column you see here from the federal tribunals. So this is what we call the hierarchy of the legal system. So you'll find that these are the lowest or inferior courts, although they are tribunals really, but you can appeal from these to the Federal Circuit Court of Australia, and from there to the Federal Court of Australia. So Federal Circuit Court and Federal Circuit, from Federal Circuit Court to Federal Court, and then to the full court of the Federal Court. And you can still appeal from there as well to the High Court. The third column, again we're going from left to right, it starts from local courts in territories. So these are again inferior courts that then could be appealed from to territory supreme courts, and finally to the Court of Appeal, the Court of Appeal of Territory Supreme Courts, and from there again to the High Court of Australia. The last column shows us the hierarchy in the states. So you have a state tribunal that you can then appeal from to a state minor courts, such as magistrate courts or local courts or district courts, magistrate courts or courts of summary jurisdiction. And from there you can appeal to the state intermediate courts, for example district courts. And from there you can also appeal to the state supreme courts, and then from there to the full court of appeal, state supreme courts, and finally to the High Court of Australia. So as you can see, there are 4 hierarchies, 2 relating to the federal court system, 1 relating to the territories, and 1 relating to the states. In the states you'll find some do have the same level of intermediate courts and some don't. For example, Tasmania doesn't. But eventually they all meet at the end, where you have all the cause of action going to the High Court of Australia, again if the appeal is accepted by the High Court. And why do we have this hierarchy in our court system? So again, the rationale is as almost always economic. So the first thing is that it provides a system of appeals. It allows different forms of hearing, and it is instrumental in the building up of precedent. So the idea of appeals is to be basically what we would call in economics a division of labor. So the idea that you don't have all the bulk of your court workload going to one particular court. So you'd have a bottleneck basically in the ability of this court to process these cause of action or lawsuits in a timely manner. So the idea is that you will have to have this limit of appeals, and as we said, appeal is not of right. Not just everyone can appeal. That's exactly why it happens. The appeal is only on merit in relation to the court actions in the lower court and the law points of law that you want to raise again in your appeal. Okay. There are also different forms of hearing. So some forms of hearing, for example, require less evidential burdens, or they have more flexibility, such as in tribunals. Or you might actually require a different level of juries, or no juries at all. And all of this really again links back to the ideas of efficiency and the costs involved with administering these lawsuits. And of course, building of precedent, and precedent in a sense is also an efficiency aspect, because it allows you to simply treat like cases alike, but it also helps make the law more certain, and it's also one of the benefits that could be linked to this idea of efficiency. Alright. Quickly we'll talk about e-courts. Of course, this is 21st century, and you're seeing more and more technological innovations in the ability of governments to function electronically. So it's not just e-courts, it's e-governments really. So anything you want to file, any kind of applications, renewals of certain policies, a lot of things now could be done simply online. You know, from the starting point to attaching documentation that's required for the application, and eventually for payments and receiving basically the approved application. And the same thing is now happening with e-courts. So you see things that you could do online include e-search or e-filing. So we're talking about filing things like affidavits, for example, or e-courtrooms. So you don't actually have to be present in a courtroom. Sometimes this could be done remotely, and it is done remotely, especially when you are dealing with criminal cases of certain types. And there's also e-case administration, in the sense that you can follow up on next hearings, for example, and changing dates for next hearings and so on, using everything that's available online. Again, this is economic in nature because it helps reduce litigation costs and it improves this idea of efficiency. Okay, let's look at identifying then the adversarial system that we have in Australia, which is of course part of the common law system that we inherited from the motherland, and describe alternative methods of dispute resolution. Alright, so we're going to look at now at our fourth learning objective, and the first thing we want to talk about is this idea of the adversarial system. What do you mean by that? So, some features. First of all, you'll find two opposing sides who argue their case. So, this system is really driven by the quality of your legal representatives. Unlike the civil law, for example, system, where, for example, in France or in Germany, where you'll find that the judge is the person who's driving this legal process. The idea that they decide what they want to hear and what the legal representatives in those jurisdictions can say, while here in the adversarial system it's the other way around. The judge is simply playing the role of an umpire, and they don't actually inform or require the legal representatives, the lawyers, to present any particular arguments. That's their job. So you are, as a lawyer, required to provide the best possible advocacy for your clients, and the judge will take the advocacy of both sides and weigh them and decide which one should actually win. So the courts are basically neutral third parties. Okay, there will be a winning side and a losing side. Okay, and in civil cases we have to provide our evidence on the balance of probabilities. So anything above 50% would actually tip you to win. Or in criminal cases where we have a higher threshold, where the Crown has to provide the case beyond reasonable, has to provide evidence or prove their case beyond reasonable doubt. All right. Now, just like we saw the story of equity evolving from the common law, we also see here alternative methods to dispute resolution to the courts. Not necessarily alternative dispute resolution, which is the ADR mentioned on this slide in the middle, but there are also other possibilities, such as the ombudsman or the tribunals or the commissions even, and even industry schemes. Okay, so instead of taking your cause of action to these courts, which is time consuming and expensive, there are other alternatives open to you where you can take your cause of action to one of these 5 alternatives. Now, we are focusing mostly on the ADR alternative in this course, and the nature of our emphasis is the assignment, the 20% assignment that you go through for analyzing a couple of scenarios and deciding which best ADRs would suit these facts. Alright. So as we said, because of the delays, the cost, and sometimes even the ignorance of the legal, either substantive areas of law or the procedural areas of law that relate to courts, or sometimes intimidation, the idea that you are basically afraid of having to go through this process. Okay, you will find that many people now, and the courts themselves and governments themselves, encourage people to look at these other alternatives. So the first one that we'll talk about is what's known as tribunals. There are also others, as we said, and there are also things like the ombudsman or even the ADRs that, as I said again, and that's why they're highlighted in red, will be the subject of your assignment. So let's then continue with our discussion of these alternatives. The fifth learning objective asks us to discuss the function of different state and federal tribunals and explain the role of the ombudsman. Okay. So on page 70 you will find that there's a discussion of your judicial and quasi-judicial on page 63, you'll find discussion of your judicial and quasi-judicial tribunals. So on page 63, there is this discussion of judicial and quasi-judicial tribunals. And the idea is really described in brief in the box at the bottom of page 63. So for much the same reasons as for the development of ADR resolution procedures, which we will talk about in a minute, the main aim of the development of tribunals has been to provide people with a cheap, quick and fair dispute settlement process in accordance with community needs, keeping formalities to a minimum. And you'll find on page 64 at the top of the page a distinction or a discussion of the differences between tribunals and traditional courts. So you'll find that sometimes we talk about tribunals as quasi-judicial quasi-judicial courts because of these distinctions. The first one is that the jurisdiction of a tribunal is usually limited to a particular and narrow area. The tribunals are presided over by non-legal experts. They are less formal and strict, okay, so making them less intimidating to a potential litigant. Less legal representation. Sometimes, in fact, like in places like the QCAT, you'll find that legal representation is generally prohibited. So you won't need actually to have someone represent you. But if you have the legal knowledge, for example, that you gather from a course like this one, you will be definitely able to go and present your case in a place like the QCAT. Appeals are restricted from such tribunals. Okay, the rules of evidence are much simpler. Okay, so tribunals can take into account factors that would not necessarily carry a great deal of weight in a court because of the rules of evidence, things like maybe even hearsay. And in tribunals, generally, the tribunal is generally given the power to be able to substitute its own decision in place of the decision maker. So the idea is that this adversarial aspect of the neutrality of courts is also a little bit more flexible when it comes to tribunals. So in the brief box on page 64 again, it says while a tribunal hearing is similar to a court hearing, formalities are kept to a minimum, and as a result of different procedures and rules of evidence, tribunals do not create precedent. Okay, even though their reports can often nowadays be found online. Tribunals are subject to judicial review by a superior court. They need also to follow something called natural justice. Okay, so as a general rule, they must publish their reasoning for arriving at a decision. And there's something called the writ of certiorari, which allows you, if you believe that a tribunal or even a court has acted beyond its powers or not complied with the principles of natural justice we've just mentioned, you can apply to a superior court to have that decision reviewed. This is what we call judicial review. And if you're actually interested in doing something like a law degree rather, later on you'll probably you will have to take a course called administrative law, where there's a complete discussion, much detailed discussion, more detailed discussion rather, on this idea of judicial review and the need to follow natural justice. Then you'll find that your book talks about a number of federal tribunals. I'll leave that for you to have a look at. And there's also state tribunals starting on page 66. And because we are in Queensland, I will highlight the discussion on page 67 of the QCAT, which is the Queensland Civil and Administrative Tribunal. So again, I will leave that for you to have a look at. Then there's a discussion of the Ombudsman, which we will see on page 70. And this word really is a Swedish term that simply means something like the agent or representative of the people. The agent or representative of the people. Okay. So the Ombudsman really, first of all, tries to exhaust all the normal avenues in an effort to resolve the matter. But if this fails, then they may then approach the ombudsman. So the parties really would have to look. So unless the ombudsman considers that it would be reasonable to hear the matter first, a person who has a problem with a government department or statutory body should try first to exhaust all the normal avenues in an effort to resolve the matter, which simply means that you try as much as possible to communicate with that department or statutory body and try to use their own internal processes for resolving conflicts to finalize that resolution. Or if that's not possible, then you can approach the ombudsman to try to and help you actually resolve the situation. So this all starts by filing a complaint. You file a complaint in writing, and if this falls within the ombudsman jurisdiction, they will send a copy of your complaint to the relevant authority for a comment. Okay, and the ombudsman then might actually make recommendations. If the recommendations are not acted upon, they could make these recommendations in the case of the Commonwealth to the Governing Council and to both houses of Parliament. Okay, or in the case of the states or territories, the governor, and they could make their recommendations to the governor and to both houses of Parliament. But they do not. The key point is that the ombudsman has no power to order rectification of a wrong where it involves a government department or statutory body. They can only make recommendations, they cannot force. So they don't really have the power that you find in the courts and the power that the judges have, where they can actually force you to do something. And examples of some ombudsmen are given as well from page 71, including the telecommunications industry ombudsman and the financial ombudsman service. Alright. We will finish then this recording with the last objective for chapter 3, to discuss the roles of the legal profession, the judiciary, the juries and parties in criminal and civil trials. But before that, I will highlight again the need for understanding the ADRs that are discussed from page 60, from page 59 rather, in your textbook. So you'll find that these are going to be the alternative dispute resolution methods that you will need to look at and learn more about in order for you to succeed in your assignment. Okay. So on page 60, you'll find that the ADRs are given to you under 3 different categories: the facilitative category, the advisory category, and the adjudicative category. Okay. So this we will talk in much more detail about in class when we discuss so what we call our colloquies or our dictorials, and we will go through some examples of the scenarios you will be getting for your assignment and how you can apply these ADRs to those scenarios. Alright, so the last then objective is again to discuss the roles of the legal profession, the judiciary, the juries and parties in criminal and civil trials. Now, in a civil action, we call the parties, so this is the first time you enter the court system, okay, we call the party that moves or brings the action, whether they are a natural or a legal person, so they could also be a company, we call them the plaintiff, and we call the other party the defendant. If we are talking about an appeal, so after one of them has lost the cause of action in the court of first instance, they can appeal on a point of law, and if their appeal is accepted, the names change. Now we have an appellant. Again, they are the persons who are moving the appeal, so they brought this appeal to the court, versus now the respondent, who's the person who will have to respond to this. They are defending basically the appeal. So the appellant could be the original plaintiff if they lost in the lower court, or the appellant could be the defendant in the lower court, in the first instance court, if they lost that action. So the appellant could be either the plaintiff or the defendant from the previous cause of action, rather from the previous or lower court action, and they can become the appellant or the respondent depending on who lost. So again, the person who loses, if they decide, the person who loses between the plaintiff and the defendant, if they decide to bring an appeal of that cause of action, then they can do so depending on whether it's accepted on a point of law, and if it is, then that person who brought this appeal becomes the appellant. So it could be the plaintiff or the respondent. Now, the terminology in a criminal action is a little bit different. So the Crown in a criminal action, of course, brings an action against an accused person. Okay. So if it's a summary offense, it's generally prosecuted, as we said, by the police rather than the Crown. So they are the ones who bring the cause of action against the accused. And if it's an indictable offense, okay, they are divided into either minor indictable or major indictable offenses. The minor ones are dealt with by the magistrates or local court, unless, of course, the accused or the defendant, basically, sometimes they are called also the defendant, they choose to have the charge dealt with in a higher court. Okay. The major ones, however, must be dealt with in the superior courts, and the Crown, rather than the police, takes over the conduct of the matter after the committal proceedings at the magistrates or local court level. Okay. Now, in relation to statutory offences, we'll just say a few things about that. You'll find that in terms of statutory offences, we have to talk about what's known as strict liability. Okay. So there are a number of statutory offences, okay, and that are really called crimes of strict liability, okay, i.e. crimes where the two elements of a crime are not required. Basically, there's only one element, which is what's known as the actus reus, or the wrongful act, and the intention, which is the mens rea, or the wrongful mind or guilty mind, is not required for these strict liability crimes, or what we simply call statutory offences. Okay. Examples of that, again, on page 75 of your course book, include things like breaches of the Corporations Act, the Commonwealth Corporations Act of 2001. And another example, again from the Act, is section 952E, which provides that it is an offense for a financial services licensee to give a defective disclosure document or statement to another person, whether or not they know it is defective. So this idea that the section says whether or not they know it's defective removes this idea of intention, and hence makes this a strict liability crime, and this is one of the examples of a statutory offense. You are given other examples under section 152G and section 1041E. I'll leave that for you to have a look at. The key point is that to remember that ignorance of such offenses, once you graduate and start working in one of these, for example, financial services sector, remember always that you need to be very aware of these sections that apply to your job description, basically, or what you do on a daily basis. So the idea then is that in these sectors of our economy, financial services, for example, you are going to be found guilty regardless of what you intended to do in the circumstances. Okay, so a higher standard where you have to be really aware of what kind of consequences your actions are going to cause, and if, for example, you're giving financial advice to your clients, and how that then could actually translate into a criminal action, basically. Okay, how that could become a criminal action against you and against your employer. Okay. Now a little bit about the legal profession, and in Australia, difference really between solicitors and barristers. The best thing to distinguish between these two is an analogy with physicians, with doctors. So if you go to a GP, a general practitioner, then that's basically your solicitor. The idea that this is the first point of contact, and the barrister instead is someone like a surgeon or someone like a specialist. Okay, so barristers are very specialized in certain substantive areas of law, and you don't go to them directly, but you go to them through a solicitor who basically is referring you to a barrister that carries your cause of action in the courts. Solicitors usually will not actually appear on your behalf in the court. It will be more likely someone like a barrister who will advocate for you in the court and move your cause of action in the court system. Now notice that in Australia there are certain distinctions in the jurisdictions. Okay, so in the Commonwealth, in Victoria, in Tasmania, in South Australia, in Western Australia and the ACT, and in the Northern Territory, qualified persons, okay, are admitted to practice as both barristers and solicitors. Okay, same thing with New Zealand, and same thing in the United States. Okay, the idea that you're just simply a lawyer. Okay. However, in New South Wales and Queensland, as a matter of law, a qualified person has to choose. They can either practice as either a barrister or as a solicitor, but not as both. So these two branches of the profession in these jurisdictions, which is New South Wales and Queensland, are mutually exclusive. However, it is possible for you to actually change from one branch to the other. Okay? It's usual for solicitors to undertake court appearances on behalf of their clients in higher courts. Okay? While it is common for a solicitor to undertake court appearances for clients, especially in the inferior courts, it's unusual for them to undertake court appearances in the higher courts. Both barristers and solicitors have the right to represent their clients as advocates before any state court. Okay. Unlike solicitors, those admitted to the bar, i.e. the barristers, will commence practice as juniors. Okay. As they gain experience and attain recognition among their peers and the judiciary, they may apply for appointment as senior counsel or silk because of what they wear, the silk robes that they wear. Senior counsels are appointed by their respective bar associations after consulting with members of the profession and the judiciary, and these only make 14% of the practicing bar of each Australian jurisdiction. You can read more about the duties of the solicitor and the barrister, the duties of solicitors and barristers on page 76. So that's what we mean by solicitors and barristers, and how they differ and what their duties are. Alright, let's then say something about the judiciary, which you'll find more on more on these in your textbook on page 77. The key point is that the judiciary are not only judges. Okay, so you'll find that we refer to justices of the peace as part of the judiciary. These are, of course, at the lowest really level, and they are simply holding what's known as honorary positions. Okay, so basically they have limited or no legal training or experience. Magistrates are the second sort of level of judiciary. These are basically salaried public servants. and they are selected from academic lawyers or government or the solicitors and barristers or even clerks of court. Then at the top of this hierarchy we find the judges. So these judges are appointed from members of the bar, although in UC3's solicitors have also been appointed to the bench of both intermediate and superior courts. Okay. You'll find more about the duties of the judge and the magistrates and the justices of the peace on page 77. Then we have the jury. Okay, and the jury is also discussed on page 77, starting on page 77. The key point is that the jury are the people, so they are both men and women summoned and sworn under oath, and their job is to determine questions of fact to the standard of fair and objective. In a jury trial, these men and women are the exclusive judges of fact. So they have to make the decision on the facts. The judge then has to decide on the penalty in criminal cases or the remedy in civil cases. Now, in criminal cases, okay, everyone has the right to a trial by a judge and a jury of 12 persons in any intermediate or superior court. In South Africa, in South Australia, an accused has the option of a trial by a judge alone, so you can elect not to have jury. And in Queensland, under the Criminal Code section 615, the court may make a no jury order if it considers it is in the interests of justice to do so. Okay. The alternative is that the prosecution may apply for a no jury order, but it will not be granted unless the accused consents. Okay. In a civil trial, on the other hand, the use of juries has largely been abolished, unless it is required in the interest of justice, with the judge deciding now in such civil cases both questions of fact and of law. And you can imagine the economic rationale behind such trend, or behind abolishing the need for trial by jury. However, where a civil case is heard with a jury, it will usually consist with a lower number. It consists of 4 members rather than the 12 we see in criminal law, in criminal cases. Only a majority verdict is required in these cases, that's the civil trials. And if the plaintiff wants to have a matter heard before a jury, most jurisdictions will provide that before the case starts, the plaintiff has to pay into the court the costs of having a jury. So again, the economic rationale that flows through these decisions. The last one I want to talk about is what's known as class action, and you can see that starting on page 78 of your course book. The key point here is that in a class action, okay, also known as grouped or representative proceedings, you'll find that individuals or businesses with similar or substantively similar claims combine together, okay, in the one legal action against the same person or organization. Something that you might have heard in the news is the cause of action against the Department of Defense in relation in water contamination, underground contamination because of some chemicals. You must probably heard others as well over the years, and there are also examples in your textbook in relation to the Competition and Consumer Act of 2010, and in relation to in relation to 2 examples shown on page 81. Now, in order for you to bring such litigation, you need to establish or to satisfy 3 elements. So the first is that there must appear to be 7 or more persons with a claim against the same person. So this is on page 79 in the middle of the page. So the first element is that there must appear to be 7 or more persons. Second is that the claims must arise out of related circumstances. And the third element is that the claims must give rise to a substantial common issue of law or fact. So what we see here is a reference to the idea of elements. Okay. So I just want to finish by emphasizing what we mean by elements. And this is an idea that will come again and again in the coming recordings and in our coverage of later chapters. In law, every cause of action and every legal theory is based on elements. So these elements are necessary for you to be able to establish the cause of action, i.e. in order for you to get the remedy that you seek from the court. If you fail on any of these elements, then your cause of action must fail. Okay. So in relation to the cause of action that relates to a class action as a legal theory, in order for you to join with others and bring one cause of action against a certain individual or a certain party, you have to be able to establish these 3 elements. There has to be at least 7 people, okay, with the same claim. It must arise from similar circumstances of these 7 or more persons, and these claims must give rise to a substantial common issue of law or fact. The last element there is that, for example, all of these people are seeking a cause of action, say in negligence, or one of the cause of actions under the criminal code. That's what it means there by substantial common issue of law or fact. Alright, I'll leave it there. You can have a look in relation to representative or class actions starting from page 78 to 81 in your textbook, and that will end our lectures for this chapter, chapter 3. As we said, we haven't covered the alternative dispute resolution methods, which are going to be the essential part for your assignment, but that's going to be done in our lectorial for that part, and it's going to be live in class. And our next lecture recording is going to be on chapter 4, which covers how law is made. Again, emphasis on precedents and emphasis on statute law. Thank you.